The first respondent has already been declared a successful participant in the election and declared to be the President of the Republic of Uganda. What more would such a person require from a citizen who has challenged him peacefully, democratically, and constitutionally? We submit that it would be unfair to gift such a person with costs from a citizen that has challenged his election. My name is Medad Lubega Sseggona. For the applicant petitioner, as a preliminary, my lords, yesterday I raised the matter of the issue of a professional nature, and we want to express our gratitude to the Honorable Court on whose orders the process of obtaining renewal of our practicing certificates was expedited and successfully concluded for the three advocates appearing before your lordships this morning. We are also grateful to the registrars of this Honorable Court and the Chief Registrar, as well as the Law Council, which complied with the directive and did the inspection of chambers in a record time. We have accordingly proceeded to submit evidence of the practicing certificates to court with the copies to council. My lords, with that and with your permission, I pray that you permit me to proceed with the application.
How much time do you need submissions?
Lords, in terms of the time I need, I think between 20 to 30 minutes.
Yeah, you're telling us why you want to withdraw, not so?
Yes, my lord.
I was thinking you would tell me 5 minutes.
In 5 minutes?
No, that's what I thought you were going to tell me.
No, I did not intend to tell you 5 minutes because it is certainly not enough, because there's one issue which is contentious.
Court is giving you 20 minutes.
I appreciate, my lord.
Please operate within the 20 minutes.
I appreciate
that. That will be for everybody.
Thank you, my lord.
Yes, yes.
My lords, this application is brought by the applicant under the provisions of the law stated. It seeks for orders of this Honorable Court to permit the applicant withdraw his petition, number 1 of 2021, and it is accompanied by 2 affidavits. The first being his affidavit, sworn by the Honorable Robert Sentamu Kyagulanyi, and supported by the affidavit of his advocate, one of his advocates, as a further additional affidavit of Ukasha Sekaja, my lords. My lords, the first part of the affidavit or grounds in support of grounds 1 to 5 explain the background. But the gist where I want to put emphasis, as required by Rule 20, Sub-Rule 3 of the Presidential election petition rules, is with respect to rule, is where I lay emphasis. My lords, the petitioner states, stroke applicant states that his decision to withdraw the petition has been influenced by the grounds foregoing, that is 1 to 5, and that it is not motivated by any corrupt bargain or consideration from the respondents or any other person. This, he restates in his affidavit, in particular, paragraph 20 of the affidavit in support. And my lord, this is reinforced by the affidavit of Mr. Ukasha Sekaja, but also confirmed by the respondents in their 3 affidavits in reply, that to the best of their knowledge, just like the applicant, The decision to withdraw is not influenced by any corrupt motive. To this extent, my lords, it satisfies the requirement under Rule 20, Sub-Rule 3 of the Presidential Election Petition Rules, 2005. My lord, to be particular for Wukasha Ssekajja's application, the affidavit in support of the motion, I am referring to paragraph 4 and 5 of the same. My lord, the power to withdraw or to permit a withdrawal is a power and a discretionary power of this Honorable Court. I invite this Honorable Court to consider the grounds in the application and the affidavit and permit the applicant to withdraw the petition for the reasons given. The second leg, which appears a little more contentious, is the question of costs. I have had occasion to discuss with counsel for the respondents with a view and bargain, not a corrupt one this time, but with a view and bargain that they concede to costs in terms that each party bears its costs. I have not received a positive answer, and their view is that they should be paid costs. In particular, I'm referring to first and second respondents. My lord, the law on costs with respect to withdrawal of petitions under the Presidential Elections Act and the rules is found in Section 61, subsection 4 of the Presidential Elections Act. It reads, and I quote, "If a petition is withdrawn, the petitioner shall be liable to pay costs to the respondent." The rules, my lords, particularly Rule 20, Sub-Rule 8, provides in similar terms that if the petition is withdrawn, the petitioner shall be liable to pay costs to the respondent. With your permission, my lord, permit me also to refer to my lords first, if I may seek your indulgence. Yesterday I was meant to apply to have our bundle of authorities admitted, which was not done because of the circumstances of yesterday. May you permit me at this juncture to pray that you permit the authorities that we presented, the band of authorities that we presented yesterday, and these were 6, together with an additional, with your permission, with just one additional authority. And from there, with your leave, I will proceed to make reference to them.
This is the one dated 4th of this month?
3rd, my lord. 4th, my lord.
Applicants,
we signed on 3rd.
Applicants' index of authority.
Yes, my lord. It is filed on 4th, which was yesterday.
Yes. Lord Attorney General, what's the view
You can't.
from the respondents? Can you address us on? Yeah.
And we have no objection.
You have no objection. Confirmed. So
we were indeed served with a band of authorities, 6 of them. Just the loose one, we don't know which one that is.
Oh, you were not served with this document?
We got the bundle, but he mentions another authority, one more authority, which we haven't received.
Mr. Lubega, is it contained in this?
No, my lord. It is not on your record, my lord.
Oh, it's not on the record?
This one is not on your record.
Oh, you intend to file, to submit another one?
Yes, my lord. Just one more.
But you did not avail them?
No, my lord, because this is an authority we picked this morning.
Yeah,
But we are happy to serve them.
No. You see, Mr. Lubega, you know, the moment you get an authority, you don't need leave of court. The first thing to do is to avail the other side. Even if court were to refuse, at least you've been gracious enough to avail the other side. Then they have something to say.
My lord, I receive your guidance with gratitude. Thank you.
Attorney General, what do you say? I have not seen the authority. You've not seen it. What do you say?
Does the counsel for the applicant intend now to serve us right now? Yes, then we
Yes,
will.
my lord, wait.
Okay. Is it a Ugandan authority or?
It is a Ugandan authority, my lord.
Okay.
Yes, we would be ready to
And
receive.
one of the parties is Attorney General himself.
Fine. The court will receive it, but please. You've used 10 minutes
Thank you, my lord.
of your time. Yeah.
Having used 10 minutes and left with 10, and I'll try to summarize. We submit that this court should find a pleasure in ordering each party to bear its costs. And the reason is that an election petition of this nature is a very important instrument of guaranteeing the safety of Ugandans in terms of democracy and rule of law. Persons aggrieved by decisions of the second respondent declaring a winner or purported winner of an election should exercise one option, which is the civil option of coming to court. The alternative to coming to court has been and has proved catastrophic in our history, and that is well represented in the preamble to our Constitution. Persons aggrieved and dissatisfied should find the route smooth to access courts of law as the final and ultimate arbiter. Only then shall Ugandans be safe and tranquility be guaranteed. This court has had occasion to consider issues of election petitions and costs in the previous 3 presidential petitions that have been presented. Beginning with authority number 1 in our bundle, which is Kizza Besigye versus Museveni Yoweri Kaguta, now Tibuhaburwa, and the Electoral Commission Presidential Election Petition number 1 of 2001. My lord, whereas there was no withdrawal in that case, and the petition was prosecuted to conclusion, this is what court had to say, and we have proceeded to highlight the relevant extracts considering the volumes for court. In particular, I'm referring to the judgment of Odoki CJ as he then was at page 8 of that band of authorities, page 8 to 9. But one important aspect that comes out...
Councillor Bega.
Yes, my lord.
Can't be right to say Odoki CJ as he then was. He didn't attain any other thing in the judiciary after that.
Oh.
So he remains Odoki CJ.
Odoki CJ, thank you, my lord.
Yes. For instance, if you're referring to me for a decision I made when I was DCJ, that's when you say DCJ as he then was.
Most obliged.
Because I attained something else after that.
Most obliged, my lord.
Yes.
I was only being misled by, it could have been a misapprehension that thereafter I became a justice of the Supreme Court after being a CJ in an acting capacity, but I'm properly guided, my lord. Yes. With that guidance, my lord, at page 8 of that bundle of authorities, he had to say this: it is well settled that costs follow the event unless the court orders otherwise for good reason. And that's where I come to discretion of this honorable court. The discretion accorded to court to deny successful party costs of litigation must be exercised judicially and for a good cause. Costs are an indemnity to compensate the successful litigant the expenses incurred during litigation. Costs are not intended to be punitive, but a successful litigant may be deprived of costs only in exceptional circumstances. In awarding costs, courts must balance the principle that justice must take its course by compensating a successful litigant against the principle of not discouraging poor litigants from accessing justice through the award of exorbitant costs. In the present petition, I'm of the considered opinion that the interests of justice require that court exercises its discretion not to award costs to the respondents. I agree with Mr. Balikudembe that this was a historic, unprecedented case in which a presidential candidate who is a serving president, and I emphasize, was taken to court to challenge his election. The petition raises important legal issues which are crucial to the political and constitutional development of the country. In a sense, it can be looked at as public interest litigation. It promotes the culture of peaceful resolution of disputes. The petition was not frivolous or vexatious, as the petitioner succeeded in issue 1 and 2. The petition was therefore of great public importance. He made reference to others, but I'll run to the other justices who, in similar terms, ordered that the petitioner, would not pay costs. Of particular importance, my lords, is the decision of Oda JSC, A.H. Oda JSC at page 13 of the bundle. And I will only quote one paragraph that I find very crucial. Second, access to court for peaceful settlement of constitutional, political, and election disputes should be available to all, the rich and the poor, which prohibitive costs of litigation would discourage effectively. My Lord, all the justices of the Supreme Court held in similar terms with respect to Justice Sseggona JSC at pages 16 to 18 of that bundle of authorities were speaking in similar terms. My Lords, the Honorable Justice Karokora JSC.
I'm giving you 5 more minutes.
Thank you,
you had eaten up your time, but I know
you,
there were interruptions.
Thank you,
so please make sure you conclude.
At page 22, Lord Justice Karokora JSC to 24 speaks in the same terms. And Mulenga JSC at page 27 to 29 and 28 speaks in the same terms. The ratio in this, my lords, is that a person aggrieved should have nowhere else to run. And that person must not be scared of the attendant costs, because deterring a litigant from accessing court may also have catastrophic consequences for the country. I submit that an election petition is not a personal matter. That's why a person is not at liberty to simply withdraw. He has to convince you, which we are here to do. My lords, Odoki CJ, in the second authority of Dr. Kizabe CJ versus Museveni Yoweri Kaguta, election petition, presidential election petition number 1 of 2006, again, a similar finding was made, and I refer to page 29 and 30 of the judgment of the Chief Justice. In addition, my lords, the other justices on this concurred. Those principles apply to the 3 respondents generally, but with particular reference to the second respondent, the Electoral Commission, my lords. The situation is made even much better and easier for this Honorable Court. In the case of Professor Arthur Peter Mutharika, a similar finding was made, and we have highlighted at page 39 of the bundle of authorities. But when you go further to Raila Odinga, at page 46 this is where there is particular reference to the Electoral Commission, which is the second respondent in our case, in addition to the principles I have already elaborated in the authorities. At page 46, that is paragraph 387 of the decision of the Supreme Court of Kenya. On costs, they write, we're aware that costs generally follow the event, but the present petition has brought to the fore the need for IEBC, that is the Independent Electoral and Boundaries Commission, to adhere strictly to its mandate and not to exhibit the casual attitude it did in the conduct of the impending election. And in defense of this petition, it is heavily public funded constitutional organ and a burden to Kenyan taxpayers with the litigation costs would be a grave matter which we deem unnecessary in the petition. Let each party bear its costs. It is not that somebody would go away without paying costs. Indeed, the petitioner would pay his costs in this case. The first respondent has already been declared a successful participant in the election and declared to be the President of the Republic of Uganda. What more would such a person require from a citizen who has challenged him peacefully, democratically, and constitutionally? We submit that it would be unfair to gift such a person with costs from a citizen that has challenged his election. Being a public interest litigation, my lords, and with more specific reference to the Electoral Commission, the affidavit in rejoinder by Ukasha Sekaja even did raise a more important legal issue that court may find pleasure in holding that the petitioner should not pay costs for the second respondent. And this is an issue of procurement. He stated he's aware that the second respondent, in procuring the services of the advocates or the law firms mentioned, due process of procurement was not followed. And we have not received rebuttal to that extent. The PPDA, my lord, requires, that is the public procurement and disposal of public assets, applies with equal force to the second respondent, who never went through that process in procuring the services of those law firms mentioned, which Honorable Stephen Tashobia mentions to have been to have been engaged. The third authority that I had intimated to court, which is going through the sanitization process of court, my lords, with your permission, and which we hope will be availed very shortly, is the decision of the High Court, which I invite you to find applicable in the circumstances, of Attorney General, the Honorable Peter Nyombi, versus Uganda Law, and the Attorney General and the Honorable Peter Nyombi versus Uganda Law Society, a decision of the Honorable Justice Musota. In particular, at page
What court was that?
my lord, thank you very much. It was the High Court. It was a decision of the Honorable Justice Stephen Musota in the High Court. And that's why.
What bearing would that have on this court?
That's why I invited this Honorable Court to adopt it and find it persuasive. Thank you, my lord. So, in particular, he reads, I agree with the submission by Land Council for the respondent.
Mr. Lubega,
Yes, my lord.
your time.
Thank you, my lord, and the beauty is that
I want to know what your prayers are.
my prayers to invite this Honorable Court to find pleasure in allowing the petition to be withdrawn and to order that each party bears its costs. I so pray, my lord.
Just a moment. Let me get back to Mr. Lubega. Mr. Lubega, what are your application? Would you like to go back there?
No, my Lord, for the costs of the application and the costs of the petition for each
No,
party.
in the application. This application you're prosecuting now.
Yes, my Lord.
What was your pleading regarding cost?
I pleaded, my Lord, that the costs be provided for.
Is that the same as saying each party should bear their cost?
My Lord, provision for costs, as I understand it, and subject to your guidance, is that when you provide for costs, you make your orders. And the orders I'm praying for is that each party bears its costs, both in the petition and in the application.
Okay.
I thank you.
Thank you. Yes, Attorney General.